Welcome to the Divorce Do's and Don'ts show. This is the show that covers all phases and aspects of the divorce process so that you can avoid common, costly, and sometimes permanent mistakes and have a smarter, saner, savvier divorce. We're going to start today off by introducing our wonderful host, Lisa Decker. Lisa is a certified divorce financial analyst and a real estate collaboration specialist in divorce, as well as the CEO and founder of Divorce Money Matters and the amazing organization that brings you this show, Divorce Town USA. So Lisa, please let us know, what do we have in store for today?
Thank you so much, Marcella, my right-hand lady here. We work together and we couldn't do this. I couldn't do this without her. So thank you for that introduction. Well, during the month of March, we've been talking about different divorce processes. We've interviewed the founder of the Amicable Divorce Network, and we've also talked about mediation and how to make that work. And today we're going to talk with Patricia Van Haren, who is a collaborative law family attorney working with families looking for ways to minimize the impact of divorce on themselves and their children. Attorney Van Haren gives them a process to learn ways to minimize the impact on their children and restructure the family unit without destroying it. Vitally important. Prior to attending law school, she worked as a family law paralegal, and her entire career has been dedicated to family law. And she believes that educating the public and providing her clients and the public the ability to be informed in the divorce process is critical. And we are so excited to have Patricia here today to tell us about this process that we're talking about and how it works and how it differs from other processes out there and how it can help you and your family in the divorce process. So Patricia, welcome.
Thank you, Lisa, for having me today. We're going to talk about some things that you should do and should not do, and some of the dangers in trying to do it yourself.
This is the place to be talking about all of that. So I'm going to give you the reins here. I know you've got some slides you're going to share with the audience. And so I'll be asking some questions along the way, but take it away, Patricia.
Okay. And can you see my slides? Okay. Do you have just my slides, not my notes?
Right.
So we're going to talk about some of those do-it-yourself dangers and why you should have an attorney at least assist you during the divorce process. So sometimes trying to save money can actually cost you more in the long run. I'm a former litigator, so I spent 10 years in litigated divorces, litigated post-judgment issues. And a lot of the time what I would run into were people with these ambiguous judgments that have been done themselves, and then they're confused and there's nothing really enforceable in there. And then they end up in court trying to litigate long after the divorce is done. So we've got several options out there. There's that full litigation model where parties represent themselves in court, the self-help centers at the courthouse, paid document preparers that are not attorneys, LegalZoom or other online programs, mediations with non-attorney mediators, or mediations with an attorney mediator, but not having your own counsel, and just what we call those kitchen table negotiations with your spouse. And why it's dangerous is generally self-help is not helpful. Self-help centers can't give you legal advice. They give you a packet of forms. They're not really able to discuss those options with you. And you're expected to know the law when you represent yourself in court. So, I went through years of law school, years of training in family law, and people who are self-represented are required to know the same laws as those that have the attorneys. If you're using a private mediator, when I'm a mediator for a couple, I can't give legal advice. I can give legal information. I can show them what they can do, but not what they should do. So when I'm acting as a mediator, I always advise they at least take the agreements to independent counsel, have those reviewed. And you just don't know what you don't know. Divorce is complex. There's lots of variables there. We have support, child custody, property division. And if you're not educated about the laws in your state, you're not going to know what you're agreeing to. You're not going to know what your rights are or what responsibilities you have and what you've signed on for. So those are some of our dangers. And so we do have options if you don't want to spend a lot of money on legal fees. Nobody wants to pay their lawyer a whole bunch of money for things that they could maybe do themselves. So you could get a consulting attorney and they can consult, give you counsel when you're going through mediation. They can also help you in litigation. If you do need to go through litigation, you're representing yourself, make appointments with an attorney. They can assist you with paperwork, review the agreements that are presented by your spouse. And sometimes we call this a limited scope attorney. So they're not necessarily your attorney of record. They're not going to deal with all the emails back and forth between opposing counsel and your attorney, like in a litigated case, but you're going to get that guidance. So we've got benefits of using a consulting attorney. If you're in mediation, they can help prepare you for sessions. They can review documents before you sign. They can guide you on what you may want to request, help you create your own proposals, and most importantly, explain that marital settlement agreement to you before you sign it.
That's critical.
That is critical. Knowing what you're signing is critical. If you use them when you're in litigation, they can help you know how to complete the forms, what you should put on there, what orders you should request. They can guide you on what arguments to make and also advise you as to potential outcomes in court. You don't want to go in asking for things that a judge is never going to grant because they're going to feel you're unrealistic in all aspects. And it can really be detrimental. If you want to utilize them for document preparation, you can get assistance in preparing enforceable agreements. You can ensure that your agreements are not vague, ambiguous. They can tell you about proper filing procedures. And you can ask questions. So again, you know what you're agreeing to. There's also the collaborative divorce process that is much less than litigation. And there, each spouse is going to have their own attorney and they're going to provide them with guidance. They commit to staying out of court and work as a team. And the attorneys are actually going to sign a disqualification agreement. Also, you're spending less money on attorney fees because you have a team approach. You might have a financial neutral. I know, Lisa, you work as a CDFA. So rather than spending money on competing forensic accountants, you can have a joint neutral to assist them in coming up with options. If you have difficulty communicating, having a divorce coach or a facilitator, they can also act as a child specialist and help you manage those emotions. I always tell people I'm a highly underqualified, high-priced therapist. I don't have that training and I'm more expensive than a divorce coach or a therapist. So utilize them for those emotional aspects. And then when we have that,
Patricia?
Yes.
I have a question. What is the disqualification agreement about?
So what that means, collaborative divorce is a private divorce process. So everything we say in there is confidential. If the collaborative process fails, which most don't, most teams are really dedicated to keeping this family out of court. But if one person chooses to take that case to litigation, neither attorney will be representing them in court. That way, and everything that's been done in that collaborative process remains confidential. So all those settlement offers that are exchanged, those continue to be protected in confidential material. So the only thing that can be used in litigation are actual documents that are filed with the court. But And that helps eliminate threats of, we'll see you in court. That goes along with other types of divorce negotiations when each people have attorneys. You know, if the attorney's not getting their way, they'll make those little threats, even though they don't intend on going to court. But we'll see what the judge has to say. We'll see you in court, to try to gain that leverage.
Right.
Because there's that disqualification clause that neither attorney is going to be representing them in court. It eliminates that and allows for really free flowing communications and work towards a settlement.
Gotcha. Now, I know in a lot of states, the other parties that are part of the team also cannot work with the divorcing parties if the process falls apart. So I'm assuming this disqualification agreement applies to them or something similar.
Yes. So in California as well, if we retain a financial mutual, they will also have a disqualification clause. So you can't take their options into court with you. Same with your divorce coach or your facilitator. Everything in the collaborative process is private and confidential. Gotcha. And so the only things that become part of the court record are, you know, the initial case filing, the signature that we've exchanged the financial disclosures, and that divorce judgment. So once that divorce judgment is filed with the court, it is an enforceable order, but none of these professionals can be brought into litigation.
Thank you for sharing and you know, letting everyone know exactly what that terminology means.
And with that approach, like, our goal is always to create agreements that are going to last for years to come. So this family will never have to be in court. And if things change as kids grow older, maybe somebody changes the job, you can always come back and hire that team or part of that team to renegotiate out of court. So the only limitation is if you're wanting to go to court.
And just a moment, and I don't want to take away from your time here because I know you have so much to share with us, but I think it's important that our audience members know that when we talk about court, we mean beyond all of the measures that you've taken before to try to settle, whether it's mediation or collaborative divorce or working with your attorneys. If you're not able to settle and you go before the judge, that's what we're talking about in this instance. And also understand the fact that in average divorce in America, and this is across the entire country, I'm sure it's higher in California, but it's $15,000 to $25,000 per spouse to negotiate your divorce in a traditional litigated divorce. That does not include having a judge or a jury decide things for you. So, you know, it can get very, very costly, and trying to keep folks out of court other than for status hearings or things that are normal case of business. You want to avoid having a stranger or a group of strangers decide what is best for you and your family. Absolutely. For many reasons. Yes.
Yeah.
And if I could too, just want to add very quickly to what you both have already said, is with a lot of these alternatives, you don't actually file until you're ready to, until you've agreed, and you go ahead and file and basically file your marital settlement agreement on the same day that you file for divorce. And so you've eliminated all of those steps in the court that lead up to that, all the mandatory hearings, all the mandatory things that the court might require in your state. And so these types of approaches they're obviously much more collaborative, which is why it's in the name, but it also saves you a lot of time and energy, and because it puts everything in your timetable, not the court's timetable.
Right. In California, we do initiate the case first because we have a 6-month and 1-day waiting period. But in a collaborative case, what we do is we file a stipulation saying, you know, we're using a collaborative process, or we put on our filing that we're using a mediator, and that way the court leaves us alone to let us do our work. So we can get through the entire case and neither party has entered the courtroom. We just let the courts know that at the beginning. This is a collaborative case. This is a mediation. And I put that right on the heading of the documents that I'm filing when I filed the initial case. That way we can work on everything. And by the time we get to the end of that 6 months, we can file an agreement.
I like that you clarified that, Patricia, because that is important. Our audience is international and can be international, but even within the United States, most states have some type of this kind of process. Most states allow for something similar to this. And it's just important that you check with whatever your state offers to you, because most of them do have this ability.
Right. And I know that the collaborative divorce movement has made a lot of steps in the international arena. Like I've met a collaborative attorney in Spain and in Italy at some of these conventions. So it's great to know that internationally, a lot of people are choosing not to litigate their cases. So we've got our benefits, and some of that we were talking about, that private and confidential process, so that nothing said in it can be used in court. And the benefits that we just discussed of that team approach, the fees spent on attorneys will definitely decrease because we have people that are skilled with the finances, skilled with working on the emotional aspects. And most importantly, a collaborative process is really child-centered. No one knows your children better than the parents. And so having parents actively involved in creating that parenting plan, making sure it's the right parenting plan for your family. If you are in litigation, the court is just going to have a stranger create a plan. They've never met your children. They maybe spent 15, 20 minutes hearing about you and your children, and they're just going to pull a plan out and say, this is what you got. So definitely a lot of benefits there. So then we've got divorce mediation, and we'll look at why it's better, but why you should still have your own attorney. So we can resolve all issues in mediation: custody, visitation, spousal support, child support, property division, the entire case. So benefits are also, it's private and confidential. So nothing said in mediation can be used outside of mediation. Just like with collaborative, the only items that are part of that court record are the legal documents submitted to the court in order for your divorce to be processed and finalized. It's much less expensive than a litigated divorce. Neither party goes into court at any time. They're not fighting with attorneys. And so for couples with not a lot of assets and minimal conflict over property, support, or custody, mediation can often be the right option. And you really run the show. So some couples can resolve all their issues in one mediation session, some over a series of sessions. And really, you and your spouse, you're going to determine the pace of the mediation and how many sessions are actually needed.
I just want to speak to that 1 minute too, Patricia, and that what I find is a mediation is a fabulous tool among many that we're talking about, but it's important that people have an understanding of the financials before they step into a mediation and try to make those decisions. And so doing the background work ahead of time to be prepared to make those decisions while you're there is really vitally important to getting your fair share and feeling, equally unhappy about what you've come out of it with, but feeling that you understood at least what was going on.
Yeah. And I have a lot of times where when we're in mediation, we will still have the parties see a financial neutral. So they go over to CDFA to help them, work on those financial disclosures, or just to understand the financial disclosures. With a lot of couples, we have one spouse that knows a lot more about the marital finances. And that's not necessarily the higher earning spouse. A lot of times we've got one spouse that's the wage earner, the other spouse is at home and in the household. But the spouse that's at home knows where all the accounts are. They know the family's budget. They're in charge of getting the taxes done, making investments, and they're the ones with more information. And the other spouse just puts a paycheck in, and the accountant really doesn't know what's going on. So if you don't understand your finances, definitely talk to somebody who will. CDFAs are trained, they know how to look at your financial documents, and they can really give you the right guidance there.
And just like the legalities, we don't know what we don't know when it comes to also the finances. So what I find is that many times things like people will say, well, I know I want to keep the house and I'm going to move, the other spouse is going to move out, but they haven't taken the necessary steps to look and see, well, first of all, can I qualify to refinance the house and get my other spouse's name off of it? And if I can, what steps do I need to take to make sure that we have the necessary paperwork, the necessary dollar amounts? A lot of times working with other members of the team as the CDFA, I will bring in the mortgage broker and say, what number do we need to back into for support in order to support this mortgage? And that is really important up front. Otherwise, you could get on the other side of divorce and find out that what you agreed upon is not attainable.
True. And, another danger is looking at not just can I refinance, but should I?
Right.
So, am I going to be cash poor? And so sometimes the option is not to keep the house. Sometimes it is. But that's where really working with the right team can help you.
Absolutely.
So important.
Guys, sorry to interrupt. I just wanted to let you guys know we have about 4 or 5 minutes left.
Oh, well, let's get through. So the reason you want to use an attorney when you have a mediator is, and Lisa, if you want, you can make these slides available for later.
Okay.
As well.
It'll be part of the recording too.
Okay, perfect. So your mediator does not represent you, so they can't tell you what you can do, and your attorney can really help you come up with those proposals. So my office has a unique solution. I saw the need for additional options for people who wanted to minimize divorce expenses. And so I have a do-it-yourself option, but it asks all the questions that you may not know need to be asked. And so right now, my process is available only in California. However, I am working on some upgrades and expanding to other steps. So I have a 3-step process where we get the information. It's a series of online interviews so that we can file and serve these initial court documents, and our California waiting period begins. And then in our step 2, we're gathering all that information for your disclosures so that those can be exchanged. In every state, I believe, you need to exchange your financial disclosures. And in our step 3, we're preparing and filing your final judgment. And that's going to include orders for property division, support, child custody. And it's a really comprehensive interview process. And so the reason why I did this is I saw many families come in after the divorce to correct problems that were, created by self-representation or those online divorce mills. Documents might be done incorrectly or something's missed, and it's really expensive to fix. And a lot of these cases ended up in litigation just because their judgment was ambiguous. We want to make sure that parenting plans are accurate. The vacations are covered, the holiday plan, and we don't want to see cases litigated where parties might agree. And again, those self-help centers and document preparation services, they can't give you legal advice, and they often don't know what should be in a judgment. So our interview makes sure that all scenarios are covered, and then I go back and check those for accuracy to make sure they'll be accepted and we're not going to have problems in future years. So with that, I'm going to leave it open for any questions that anyone might have. Again, my hope is that my program is going to end up in all 50 states by the end of next year. So by the end of 2023, I am having conversations with attorneys in other states to formulate it for them as well. So taking
That's
care
great.
of some of those issues.
Thank you, Patricia. And we'll actually have time after the live event for anyone with us today to ask those questions. Thank you so much.
Great, thank you. So I will stop my share.
And Marcella, you have some slides to go over for some things for our listeners?
Absolutely. Just very quickly, we'll share some things and some resources that we want to make you guys aware of. We know that many of you are in different places. We also want to remind everyone that the information that Patricia shared with us today, even though she's practicing in California, those divorce basics, those are basic in every single state. You have to work out the financials and the parenting plan, and you have to have it all. If it's not agreed to, then it goes to litigation. And those are basic steps that just about every state follows in different manners. California has a waiting period, other states don't. But those basic concepts and principles of how the divorce process works in and out of court, always the same.
Right, but you definitely want to consult with an attorney in your own state about what your particulars are. Absolutely.
Absolutely.
And to
We're all in
help
agreement on
everyone-
that.
We're all in agreement, exactly. And to help everyone kind of decide what is the best divorce process for me. Should I do it amicably? Is that possible? You might be surprised, because even in cases of conflict, you might still be able to divorce amicably. If you have kids, how and do you start with your kids first? Is it possible to do the parenting plan before you do anything else? What about if finances are an issue? What if you are the spouse that doesn't really understand the financial part of your marriage? Maybe you want to start there. Basically, as you can see from the map, the only place no one wants to end up is in the lower right-hand corner, because it's really expensive and very time-consuming, and it'll cost you a lot of energy. So Divorcetown USA has created this roadmap that comes with an ebook, and it's going to walk you through some of these different things that we talked about today, so that your family can make the very best decision for you. Because as we've discussed in past episodes, you're still going to be a family. If you're parents, you're still going to be parents. You're just going to have to do it differently and in a different way. And so this is hopefully going to help everybody make better choices and have better options when it comes to the divorce process. Now, we talked a little bit about financials today. We're going to offer you a resource to help you get organized. And for those of you in California, this will probably help complement Patricia's system, because Lisa's put together a free divorce financial fitness kit. It is the basics. It's a worksheet of documents that you're going to want to start to gather. It's going to help you find out where to get some of that information from, and also start thinking about questions that you're going to want to ask your attorney when you do meet with them, because we really do encourage, no matter how you do this process, at some point you should be consulting with legal counsel.
And earlier is better, folks.
Absolutely.
Definitely.
And so finally, our last resource we want to bring to you today is the Divorce Help and Hope Support Group. The next meeting for this support group is going to be on April 7th. This is a support group of your peers. This is a support group of people going through divorce, or those who have been through the process but are either still healing, or we actually have some who come regularly just to help those who aren't quite there yet, which is a very beautiful thing. These meetings are moderated by our Divorcetown USA professionals. So there's always someone there to moderate the meeting, to answer questions you might have, and to help you find the resources that you need as you go through your divorce recovery. If you would like to join the group, it's open to anyone, and it's available at meetup.com. Just look for the Divorce Help and Hope group.
And there's no charge.
Finally, no charge. Thank you, Lisa. What do we have next week? Next week, we have an attorney from Florida. And she's actually going to talk to us about how you can divorce in peace. What do we mean by that? Well, you'll have to tune in next week to find out, but Cindy's going to walk us through the peace process and how it works. We want to thank all of you for being part of our show today. We hope to see you next week, same time, same channel, as we continue to help the world divorce better, one family at a time. Thank you to all of you.